Corey Talbot. I am an antitrust partner at Holland and Hart, and I'm here with April Medley today. April's also an antitrust partner at Holland and Hart, and we are presenting today as part of the healthcare compliance webinar series on antitrust. And so with that, we will go ahead and get going on our presentation. As you can see, today we'll be discussing antitrust law in healthcare. We should have time at the end for some questions. If not, feel free to email in questions or call with any questions. We're happy to answer those. And with that, we'll go ahead and get started.
Okay, if you take away one thing today, make it be this. Anything else we can help you with?
All right, so what we're going to be going over today is we're going to be doing pretty high level review of antitrust topics. First at the federal level, and we'll be talking about the various federal statutes that address antitrust issues. That includes HSR filings. HSR filings cover mergers and acquisitions that hit certain size threshold. They're usually larger transactions, but the principles apply in a lot of different antitrust settings, and so it's worth talking through those. And plus, that regime has changed recently in the last couple of months pretty significantly, and so we want to let you know what's new in that area. After that, we'll talk about some of the enforcement trends with the change in administration. You shouldn't be surprised that just like the new administration differs from the old administration in a lot of ways that we hear about in the news, it differs in antitrust enforcement. And so we'll talk about sort of where things have been and where they appear to be going, although it's pretty early with the new administration. And then finally, we're going to be talking about state law issues and state enforcement, state policies that address antitrust issues.
So the key federal antitrust laws that we'll be covering are the Sherman Act. We'll talk about both Section 1 and Section 2. Then we'll move into the Clayton Act, which was supplemented by the Robinson-Patman Act. Then we'll cover the Federal Trade Commission Act and the Hart-Scott-Rodino, or the HSR Act.
All right, why don't we start with Section 1 of the Sherman Act. This is the antitrust conspiracy statute, and this statute outlaws every contract combination in the form of trust or otherwise, or conspiracy in restraint of trade. By its terms, this statute would actually make every contract illegal. Anytime you enter into an arrangement, you are in some sense restraining trade. If you go to Target and buy a pair of pants, you are restraining trade because now nobody else can buy that pair of pants that you just bought. And so what courts have done with this statute is they've applied a reasonableness standard to it. And so what we're talking about is contracts that result in an unreasonable restraint of trade, which is they have a substantial or significant adverse impact on market-wide competition. So it's not just the impact of a single, we're not just looking at a single competitor, a single purchaser, we're looking at the effect on market-wide competition. And so this is not a statute that covers unilateral activity. We're talking about agreements between two independent economic entities. And the Sherman Act can result in both, is something that the DOJ has exclusive enforcement authority for at the federal level. But through the Clayton Act, the FTC can also effectively enforce the Sherman Act. Now, the difference is often when DOJ is enforcing it, it is enforcing it criminally as opposed to civilly.
So if you're looking to get away from it all, you want to enter into a per se agreement, you can go to prison. Per se means the agreement is illegal. You can't justify it by pointing to, pro-competitive effects. Courts simply presume these types of agreements are illegal. So one of these is a naked horizontal price fixing Naked means it's unconnected with any redeeming larger enterprise. Naked versus ancillary can be tricky. So an example is where a provider controlled contracting networks jointly negotiate on behalf of their competing members. The question is that naked or ancillary? Ancillary. And that depends on whether the network providers have integrated their delivery of care through the network and whether the joint negotiations substantially aid the network in achieving more efficient delivery of services. It has to be reasonably necessary to achieve the efficiencies from network cooperation. Another type of per se agreement is bid rigging. And this doesn't come up a lot in healthcare, but it's exactly what it says, right? It's when you're rigging a bid, there's a predetermined winner. And again, you'll go to prison if you do it. The third kind is market allocation. So for example, hospitals agree that one will not provide services offered by the other. You know, we'll do cardiology, you'll do orthopedics. That's a problem. You may be able to work around this through joint ventures. This comes up, for example, in rural areas where you don't have enough patients in the area to justify both hospitals having specialty groups. And so again, one way to work around it is a joint venture. There's also, you know, civil and criminal liability. For civil liability, it's important to be aware you can have treble damages in private actions.
All right. Those are agreements that are per se illegal, and that is in courts' experience that there is never a case where the pro-competitive benefits of those types of agreements outweigh the anti-competitive benefits, and that's why those are deemed per se illegal. Other agreements, though, can have both pro-competitive and anti-competitive impacts. And for those types of agreements, if courts or enforcement agencies are looking at those, they apply, instead of the rule that it is a per se illegal agreement, they analyze the transaction or the arrangement under what's called the rule of reason. And the rule of reason is sort of what it says. You determine whether the particular restraint on trade is reasonable or unreasonable. And so this pops up in a lot of different types of arrangements. Horizontal exchanges of price information. Now, April just talked about how naked horizontal price fixing, and that is where competitors, and when we talk about horizontal and vertical, horizontal is competing. You're on the same level. Vertical arrangements are ones where we're talking about suppliers and distributors, vendors, and so they're supplying down to you so that you can effectively compete with other people. Horizontal exchanges of price information are not per se illegal. It's not having access to the information itself that makes it an antitrust violation. It's what you do with it. And if you have an agreement where you're exchanging price information with competitors and you're agreeing that you're going to compete at a certain level, that's the naked horizontal price fixing that is illegal per se. Simply exchanging the information, though, is not a per se violation of the antitrust statutes. And this comes up quite a bit in trade associations. So if you've got a trade association where you're tracking information about salaries in an industry and you're exchanging salary information as part of that, there are certain safeguards you would need to follow to be safe in doing that. It's not a per se violation, but it does put you at risk. And so in any type of transaction where you're exchanging price information, you need to look at the antitrust impact of that. Could this result in price fixing? Could this result in anti-competitive conduct that could expose you or your organization to antitrust liability? Other types of arrangements that can raise anti-competitive concerns: group boycotts, concerted refusals to deal. For the most part, you can choose who you want to do business with. Where you can get into trouble is where you try to agree with other people about who you as a group will and will not do business with. Joint ventures, April talked about that as a potential solution for a market allocation problem. And so those can often be pro-competitive, but they also raise risks of anti-competitive conduct. Horizontal mergers. These are mergers among competitors, and they can often help competition by getting rid of inefficient competitors and helping to reduce costs and raise efficiencies so that you're a more effective competitor moving forward after a merger, but it can also reduce competition. For example, if there are two hospitals in town and they merge, there's no longer a competition at that there's no longer competition at that level if that's what the market is. The geographic market for hospital services, if it's that town, you've eliminated competition, so that can be problematic. Vertical mergers can raise competitive concerns too, as you reduce the number of players in the supply chain. Tying arrangements can be problematic, exclusive dealing, and vertical price fixing and market allocation agreements as well, not just the horizontal ones that April talked about, can also raise some concerns. But again, they can also be pro-competitive. And so these types of agreements are really something that you need to analyze on a case-by-case basis. You can't just look at this and say, oh my goodness, it's an exclusive dealing arrangement our vendor wants. We can't do that. It would violate antitrust laws. That's not the case. It can be and often is something that is pro-competitive and will result in the more efficient provision of goods or services.
Section 1, we're going to move on now to Section 2 of the Sherman Act. Section 2, these are monopolies and attempted monopolies, which is unilateral conduct where a firm is trying to exclude competition from the market so it can obtain or maintain market power. And market power is just the ability to raise prices above a competitive level. So for example, if in your town you have 4 fast food restaurants and one of those restaurants raises prices, competitive results is that a customer goes to the other 3 restaurants, which means it can't maintain prices above a competitive level. If one has market power, it can raise prices and not lose power. There's nothing inherently wrong with market power. The question is just whether getting or maintaining market power was done through improper conduct.
Yeah, and just to follow up on that, a few points. Generally, a Section 2 claim is going to be a claim about unilateral action. This is one particular firm acting in an anti-competitive way, but it can include a conspiracy where multiple independent economic actors are conspiring to form a monopoly or at least to have a very few number of competing firms and eliminate competition. When we're talking about a monopoly, does this mean you just can't be the best and put everybody else out of business because you are the best at what you do? Your physician group provides the best services in the area, and as a result, all the other physician groups leave. Is that a violation of Section 2 of the Antitrust Act? No, of the Sherman Act. No, it's not. That's perfectly appropriate, and in fact, that's the sort of competition that the antitrust laws are designed to foster. If you are a better competitor than your competitors, that's the result that we want. We want effective competition to eliminate poor competitors. And so there's nothing wrong with gaining a monopoly or gaining market power as a result of competition. Where you get into trouble is where you engage in exclusionary conduct to eliminate people from the market or to keep people out of the market. A good example of this is what the Department of Justice alleged that Google was doing in antitrust violation or in violation of the Sherman Act. What Google allegedly was doing when somebody came up with a product or service that would compete with Google, one, Google would undercut them on price, and I know that Google itself is free for users, but there are costs associated with it, and Google would undercut them, for instance, on advertising. And as a result, these companies simply couldn't make money, and Google was willing to take a loss in that area in order to eliminate a competitor. And that the DOJ said was improper, and you couldn't do that. That was exclusionary conduct. It's not competing, it's excluding somebody from the market. The other thing that Google would do is they would just buy some of these nascent competitors that were coming into the marketplace. And Google would just buy them before they got really valuable or really successful. And that way they would eliminate competition. And the DOJ said that's exclusionary conduct. You're keeping new innovations out of the marketplace, and it's improper. So yes, you can compete to get a monopoly, and you should. That's the goal of antitrust law, is for people to be able to compete effectively and put inefficient competitors out of business. But you can't engage in exclusionary conduct to keep people out. The other thing that comes up a bit in this is a concept called monopsony. So a monopoly is where, I have all of a particular market. I have 100% of the market share for a certain product or service. And so when I'm selling that, people have to come to me to get it. And as a result of my monopoly, I can charge what I want. I can limit my output. I can reduce or raise quality as I see fit. And those sorts of things. Competition is designed to maximize quality, maximize output, and minimize price. And in a monopoly, you don't have to worry about that. A monopsony is kind of the flip side of that. Instead of talking about a seller, now we're talking about buyers. And so what will happen with some conduct, if you have a buyer who is the only buyer in a particular market, and there are several sellers that are trying to sell to that monopsonist has the power to demand lower prices from sellers because of the monopsony power. It's the only game in town. It's the only person to whom you can sell your products. Monopsony is not mentioned in the Sherman Act, but it has been recognized by some courts and by the enforcement agencies too. So it is a potential risk if you find yourself, as the result of some improper exclusionary conduct, to be the only purchaser of some particular product or service.
So let's move on to the Clayton Act. We'll talk about these a little more detail. It's a bit of a grab bag. It covers a variety of areas. So Section 2, it covers price discrimination, and this was supplemented by the Robinson-Patman Act. Section 3 covers exclusive dealing contracts. Section 4 covers
Section
it's also at Section 3 covers tying arrangements, and Section 7 covers anti-competitive corporate mergers and acquisitions. Section 8 covers interlocks of directors and certain officers. Generally, this only leads to civil liability. So let's get into them.
Yeah, the first area that we're going to talk about here is price discrimination. Price discrimination prohibits suppliers from selling goods of like grade and quality at different prices to competing resellers. And so this is something that the Clayton Act addressed this pretty high level. Congress enacted the Robinson-Patman Act to supplement this. And so the Robinson-Patman Act is part of the Clayton Act now. And what it's designed to do is to address these types of price discrimination where the effect may be substantially to lessen competition or tend to create a line of monopoly in any line of commerce. So that's the issue that we're trying to address through this price discrimination. This has been a dead letter for a long time. The FTC brought a case in 1988. After that, they brought another one in 2000, and that's pretty much it. Nothing has really happened with the Robinson-Patman Act for a long, long time, and the reason is that the rationale for the Robinson-Patman Act goes against the rationale for the other antitrust statutes. The the ultimate goal of the antitrust statutes is to protect competition. And in doing that, what you're looking at is consumer welfare. Well, if you've got a supplier that is selling goods of like grade and quality at a lower price to certain resellers, that can be very good for the consumer. And so the Robinson Patman cases would come up and they would say, well, they're selling to them for less than they're selling to us. And courts would look at that and say, well, that sounds good to me because now you're allowing consumers options to purchase from that reseller that got it at a lower price, and they'll be able to get it at a lower price. And that's good. That's good for the consumer. And so I don't see what the problem is with an arrangement like that. So that's been that theoretical tension between the Robinson-Patman Act and the other antitrust statutes resulted in very little enforcement of the Robinson-Patman Act. Early in the Biden administration, though, the FTC started making noise about reinvigorating enforcement of the Robinson-Patman Act. And ultimately, at the very, very end of the Biden administration, the FTC brought two actions under the Robinson-Patman Act. One was against a company called Southern Glazer's Wine and Spirits. And that company is the largest US distributor of wine and spirits. And what the FTC alleged was that Southern charged significantly higher prices for selling identical bottles of wine and spirits to independent retailers than it did to large chains that competed with those independent retailers. And as a result, these independent retailers were having trouble selling the product because they were just being undercut by these large chains that were getting it for much cheaper. The FTC filed a second suit against Pepsi, very similar allegations, saying that Pepsi was providing a big box retailer with an unfair pricing advantage that it didn't offer to competing retailers. And so, I mean, these are the first two Robinson-Patman cases in 24 years. I will say the Trump administration recently dismissed the case against Pepsi. The Southern Glazers, though, I think is still ongoing. It's pretty early on, so not much has happened the last I looked, but that case is still ongoing. One interesting result too, I think, of the FTC ramping up enthusiasm for the Robinson-Patman Act is that there have recently been a couple of private actions that have been brought. One was brought by U.S. Wholesaler Outlet and Distributor Inc. And that was a group of wholesalers that competed with Costco. And they alleged that the maker of 5-Hour Energy drink was giving favorable pricing to Costco. And that case is back in the district court. It was actually dismissed, and then that was reversed on appeal. So that case is around. The other one was also involved Costco. This was the Prestige Brands case, LA International versus Prestige Brands. And this involved eye drops, medicated eye drops for the brand Clear Eyes. And they would make payments to Costco in exchange for Costco performing various advertising, promotional services. And similar payments were never offered to Costco's competitors. And the jury found, after a jury trial, they found that Costco's payment violated the Robinson-Patman Act, which was interesting because in that case, the defendant was the medicated eye drop brand, but the payment program was set up by Costco, not the medicated eye drop brand. So interesting case. Robinson-Patman is a really, really technical act. There are a lot of exceptions to it. But it, kind of broadly speaking, it does stand for the proposition that if you are selling to resellers, you need to sell at the same price to them. Now, there are all sorts of exceptions to that. So if you run into an issue where Either you're selling to different, to different entities at different prices, or if you're finding that a vendor is selling to you at a different price, they're selling to somebody else, it could be a potential Robinson-Patman Act violation. A lot of times in healthcare where this will come up, well, a lot of times is relative, but frequently when it comes up in healthcare, it'll come up in the context of vendors giving discounts, for instance, to nonprofit hospitals. So you're going to sell your product cheaper to nonprofit hospitals than for-profit hospitals. And that can violate the Robinson-Patman Act. Again, there are exceptions to it, and if you or somebody you know is doing that, you should probably make sure that you're not running afoul of the Robinson-Patman Act.
So the Clayton Act also covers exclusive dealing contracts. Such contracts involve selling with the condition that the buyer stop dealing with the seller's competitors. And this under Section 3, it's where the effect may be substantially to lessen competition or tend to create a monopoly in any line of commerce. So there are a lot of exclusive contracts in vertical supply chains. It allows people to be more efficient in the way they buy and sell. As a result, that's pro-competitive. It allows parties to benefit consumers. The challenges come up, well, there's some frequent ones in healthcare. For example, an arrangement between a hospital and a hospital-based physicians that excludes outside physicians from providing services there. And these aren't per se illegal, but they may be challenged. Another example in the healthcare area is arrangements between health plans and other providers that foreclose the excluded providers from treating the health plan's members. So this comes up all the time. It can be an improper restraint on trade, but it can also be an appropriate way to more efficiently provide services. So again, these aren't per se illegal. It just comes down to the facts of each arrangement.
Okay, the next area is tying arrangements, and tying arrangements can be good, can be bad, depending on how they're set up. So a tying arrangement is where the seller will only agree to sell a product or service, which is called the tying product, if the buyer also purchases a different product or service, the tied product, right? So if you buy one, you buy both. You have to do that. The biggest example of this is probably the Microsoft antitrust litigation. And in this case, Microsoft, with its operating system, tied the purchase of its web browser to the purchase of the operating system. If you bought the operating system, you also had to buy the web browser. That was the tied product. And DOJ came in and prosecuted and filed suit and said, hey, you can't do that. You've improperly tied the web browser to the operating system. So that's probably the biggest historical example of this coming up. Generally, tying arrangements are analyzed under the rule of reason, but you can see there are circumstances where a tying arrangement would be per se unlawful. You've got two product services involved. Agreement to one is conditioned on buyer's agreement to purchase the other. The seller has, and this is where it gets per se, seller has sufficient market power for the tying product to restrain competition in the market for the tied product. And that one can be complicated because you've got to analyze market power for the tying product and market power for the tied product. And so you've got some, pretty complicated analysis there. And then the tying arrangement affects a not insubstantial amount of commerce. And so the point really is if you are doing a tying arrangement, you need to be careful because it can be it can raise antitrust risk. In the healthcare arena, this can pop up. There are tying, there are tying arrangements around in healthcare. Probably one of the earliest examples of this in healthcare, and this kind of changed. Actually, it's a big antitrust case generally because it changed the approach to tying agreements generally. And it's a case called Jefferson Parish out of Louisiana, and in that case, a hospital signed an exclusive hiring contract with an anesthesiology group, and they alleged that the allegation was that hiring contract was a tying arrangement because the users of the hospital's operating room, that was the tying product, the operating room, were also compelled to purchase the hospital's chosen anesthesia services. That's the tied product. And unanimously, the court held that though the agreement was in fact a tying arrangement, it was not per se illegal. So this is where we got tying agreements under the rule of reason. And the court noted the essential characteristic of a per se illegal tying arrangement is where a seller uses market power to coerce a buyer into purchasing the tied product. And the hiring contract in Jefferson Parish wasn't per se illegal because even though the hospital had a 30% market share, that wasn't enough to force sales or to raise antitrust concerns. The court's focus on the hospital's sale of service to its patients instead of its hiring contract with the anesthesiology group created what has since been referred to as a partial per se rule. It kind of blurs the line between the per se and rule of reason analysis, but it changed it. And so that case has continued to be applied in tying cases. It was applied in a case after that in the early 2000s in Utah for a managed for a group of optometrists that filed suit against IHC. It's been applied in the St. Luke's case up in Idaho. And so those kinds of tying arrangements have had certainly an impact in our footprint over the last couple of decades.
Let's talk about mergers now. Section 7 bans transactions whose effect may be substantially to lessen competition or tend to create a monopoly in any line of commerce. They're anti-competitive corporate mergers and acquisitions. There's several theories of harm. The first is unilateral effects. So in a horizontal merger, you have two competitors merging. The question is, what's the impact? Does it now have market power? Does it have more than 30% of the market? If it does, then you're going to draw some scrutiny from the agencies if they're aware of the transaction. Another theory of harm is the coordinated effects. The question is, will the merged entity be able to coordinate with other competitors improperly as a result of the merger? If so, this again may draw some scrutiny. Corey talked earlier about monopsony. The question again is the merger going to impact vendors that currently sell to the merging parties? Same thing, if so, scrutiny. And another theory of harm is partial acquisitions. So Section 7 reaches not only full acquisitions or acquisitions of control of the target, but it also acquisitions of minority interests, which are called partial acquisitions. Those that do not result in control typically raise fewer concerns than a full merger because the acquiring party will not be able to direct the competitor's competitive decisions. However, partial acquisition concerns increase where the stake in the target is greater. The 2023 merger guidelines set forth 3 types of concerns that are considered in partial acquisitions. The first is influence over the target firm's competitive conduct. For example, determining prices or affecting strategic plans in ways that may induce the target firm to compete less aggressively or to coordinate its conduct with the acquiring firm. Another concern that's considered is reduced incentives for the acquiring firm to compete. For example, because the acquiring firm now receives a portion of any lost sales to the acquired entity via an increase in the value of its minority interest. A third concern is the acquiring firm gaining access to non-public, competitively sensitive information. This is, prices, costs, or contract terms. So those are the theories of harms. We also want to talk about the evidence of harms. This is the things that agencies and a private claimant would look at to determine if your merger would cause harm. So the first is market shares and concentration. Basically, this is, the more market share you have and more concentrated the market is, the more likely it will have anti-competitive effects. Natural experiments. This is looking at whether there are similar transactions that occurred in the past and how have those impacted competition. The third is close head-to-head competition. The question we're thinking about there is, are the merging parties close competitors, such that removing the competition from the market will substantially lessen competition? The fourth is potential competitors. Will the merger eliminate a potential competitor? Customer complaints. Agencies are, they'll reach out to your customers to see what impact of the transaction would be on them. And the agency has gotten a lot more aggressive about doing this type of reach out. So you can expect that to occur if you're dealing with a merger. The last one is looking at the actual effects of consummated mergers. So agencies rarely do this. Once a deal is done, they rarely attack these because it takes a lot of resources to do so. But they have done it, including in the St. Luke's case that was about 15 years ago. St. Luke's bought some physician group, and the court said it was an anti-competitive merger, and it undid the deal.
Yeah, and now we'll look at this kind of under the vertical with vertical mergers. The harms from vertical mergers are pretty similar. And so agencies look at kind of a lot of the same stuff they look at as far as harm that they look at for horizontal mergers. It can be a little trickier to find the harm, but that's what they do. The danger of vertical mergers, and so this is mergers up and down the supply chain, and the danger is foreclosure. For example, let's say that that you've got a hospital that acquires well, let's say you've got a vendor of medical devices that acquires a hospital. Kind of an unrealistic situation, but a vendor of medical devices acquires a hospital. Is the vendor going to now foreclose sales of its product to other hospitals? That's a kind of thing that can be, that's the risk you run. Better example would be a hospital acquires a physician group. Is the hospital going to foreclose opportunities for other physicians who are not part of that physician group to compete and to work at the hospital? So Section 7 also bans anti-competitive corporate mergers in the vertical setting. And what in looking at the dangers of foreclosure, what courts will look at is, one, the availability of substitutes. And that's, okay, if there are fewer alternatives for you to the merged firm's related product, then the merged firm can limit access, and that's a problem. Can a rival switch away from the relevant product and get it from another supplier, or switch to another product that will be just as effective? It looks at this competitive significance of the related product. And so sometimes, if the product is a very competitively sensitive product, you're going to have a lot more agency scrutiny. It looked at the effect of competition in the relevant market. As a result of the merger, what is going to be the impact on competition? If dependent firms of the vendor, whoever that is, can be excluded altogether from the market, that could significantly impact competition. And so again, going back to the example of a hospital acquiring a physician group, if other providers are then excluded from the hospital, that can be that foreclosure of competition can make the transaction suspect from an antitrust perspective. Courts also look at competition between the merged firm and dependent firms. And again, the risk is that the merged firms will be able to have a competitive advantage over other competitors and effectively exclude them from the market. We're going to also look at barriers to entry. Notwithstanding a merger, are there other competitors that can enter the marketplace and still compete with the merged firms? And if that's the case, that's probably going to be a really good factor in pointing to why this is actually a competitive a pro-competitive transaction, if there are low barriers to entry, then other people can come in, and that sort of serves as a check on the ability of the merged firm to try to raise prices or lower quality or lower output. Um, They'll also look at the prior transactions or actions to see how prior behavior has been between those same parties. They'll look at market structure to see if this really is, see what other substitutes and competition are out there for the related product. And so there's a lot of, there's a lot of things you can look at. And then finally, the nature and purpose of the merger. Most mergers, I think, are done to improve parties' ability to compete. If they are done, though, to foreclose rivals, then the agencies will assume that the merged firm has the ability and the incentive to do so, and you can find yourself in trouble as a result of that vertical merger. So those are some of the things that agencies and courts look at with respect to mergers, both horizontal and vertical.
The Clayton Act also prohibits interlocking directorates. This means that the same person cannot hold a position on the board of directors of competitors or serve as a board elected officer of competitors. This is a really, really technical area. The competitors must have capital, surplus, or undivided profits exceeding certain thresholds set out in the statute. And if the competitive sales fall below specified levels, then there are safe harbors that allow the interlock. So we won't get into a number of details here, but if you are on the board of directors of a competitor, or if you're contemplating having someone serve as a director of a competitor company, then you need to get antitrust counsel to look into the issue beforehand. This is a point of emphasis in the last administration, and it appears to continue in this new administration.
All right. So that's kind of an overview of the substantive parts of the Clayton Act. Moving on, next we're going to talk about briefly the FTC Act. The FTC Act is really what provides the FTC with authorization to enforce antitrust statutes. This is the statute the FTC uses to sue for violations that would really fall under the Sherman Act. Interestingly, the language of Section 5 is that it outlaws unfair methods of competition affecting commerce, and unfair or deceptive acts or practices affecting commerce. It's broader. The language itself is broader than what is in the Sherman Act. And the FTC has the exclusive authority to assert claims under the FTC Act. And it's been interesting to see how that's played out, because historically, the FTC has, while it's been an open question as to whether the FTC could go beyond the Sherman Act in enforcing it, it really hasn't. It's kind of acted in lockstep with DOJ in enforcing the Sherman Act. And so as a result, it's interesting because you on the one hand, you do have, there's a line of Supreme Court cases that talk about how the language does appear broader than the Sherman Act, and that at least technically, the act could cover things that are not covered by the Sherman Act. An example of this would be for nascent deals, and so these are for deals that aren't done. It allows the FTC to go in and put a stop to deals that could be anti-competitive. And so there you do have situations like that where the FTC acts broader. The Biden administration made some noise about being a little more aggressive with the FTC Act than it had historically been. And there were, despite the fact that, like I said, there is this line of Supreme Court cases pointing out that it's broader, there's also a line of cases that point to the fact that the FTC has traditionally treated this as being co-equal in scope with the Sherman Act. And so it's a little unclear. It seems unlikely this is going to be an issue in this administration. It's not a fight that the current administration seems interested in pushing. And so for now, that theoretical difference between the scope of the Sherman Act and the FTC Act is probably not going to go anywhere. it really is something that's probably just gonna stick with the way that it's been enforced in the past, which is co-equal with the Sherman Act. And in fact, in 2015, it's the most recent official statement we have from the FTC. It issued a statement of enforcement principles regarding unfair methods of competition. And it outlined in a statement of enforcement principles the rationale for their enforcement. Most commentators read that statement to say, yeah, the FTC is going to continue to treat this like it does in lockstep with the Sherman Act. And so that's probably where this is going to go. Basically gives the FTC authority to act and enforce antitrust statutes. Probably not going to see a lot in this administration pushing to expand that.
I'm going to talk now about the HSR Act and HSR filings. HSR filings came into being as part of the Hart-Scott-Rodino Act in 1976. And as part of the act, the FTC was tasked with setting up rules that govern the HSR filings. The FTC and the DOJ both provide guidance regarding filings formally and informally, and we can also ask questions about specific transactions directly to staff attorneys in the pre-merger notification office at the FTC. The goal is really just to get information to the FTC and the DOJ so they can determine whether a proposed transaction is anti-competitive and whether it runs afoul of US antitrust laws. Agencies can't review every transaction, so there are thresholds designed to ensure that the agencies review material transactions that are most likely to have an impact on competition. The rules frequently change. Most of the changes are minor, but earlier this year, we had the biggest change in the rules since their initial promulgation. So we're going to talk about when a filing is necessary and what it requires.
Okay, so under the HSR test, there are a couple of there are a few threshold issues you need to determine whether you need to submit an HSR filing. And just kind of big picture, these are pretty substantial filings. We're running low on time, so we're going to skip over some of the slides we have on the HSR Act, but it's quite an undertaking. The fees for HSR filings range anywhere from several tens of thousands of dollars to over $1 million just to file the fee with the FTC and the DOJ. Or just to file the form with the FTC or the DOJ. So it's a pretty serious undertaking. And so as a result, this doesn't apply to every deal. It applies to deals that meet these size of transaction test threshold, the size of person test threshold where it applies, and it's not exempt or otherwise immune from the HSR Act.
So looking at whether you need to file the size of transaction test, essentially, the transaction is reportable. You do need to file if the acquiring person will hold aggregate voting securities, assets, or non-corporate interests of the acquired person valued at more than 126.4 million. A lot of these dollar amounts that we'll talk about are adjusted annually. Under the test, there are some circumstances where it's not reportable. First, when we're talking about acquisitions of non-corporate, so LLC or LLP interests that do not confer control of the target. For example, the right to 50% or more of the profits of the non-corporate entity, or 50% or more of the assets of the non-corporate entity in the event of dissolution. Those are not reportable. Acquisitions of non-voting securities are also not reportable.
All right, so that's the size of transaction test. Assuming the size of transaction test is satisfied, you also have to satisfy the threshold of the size of person test, unless the transaction value is over $505.8 million. And then a filing is required, barring an exemption, regardless of what the size of person test would show. But for these transactions that are valued between 126.4 and $505.8 million, you have to look at the size of person test. And that is essentially it's a question of whether the parties to the transaction are sufficiently large to warrant merger clearance by the FTC and the DOJ. So it's, again, like the size of transaction test, awfully technical analysis that you get into. You're looking ultimately at whatever entity or person controls the entity that is either acquiring the target or is the entity being acquired. You're looking for the person or entity that controls them. And there are various legal tests that set out what that control is. Ultimately, you kind of work your way up the chain to the person or entity who controls the parties to the acquisition. Those people, the ultimate parent entity for the buyer, the ultimate parent entity for the seller, have to submit the HSR filing. And so those are the ones that you determine whether they meet the size of person test. And the size of person test says, okay, one of the parties to the transaction has to have annual net sales or total assets of at least 252.9 million. So if neither one has those, you don't meet the size of person test. If one of them meets it, then the other one has to meet this second requirement, which is that you have annual net sales or total assets of at least 25.3 million. But, and this is, it gets tricky. If that person's not engaged in manufacturing, then they have to have annual net sales of 252.9 million or total assets of at least 25.3 million. So I get it. This is not the most exciting part of our presentation by far. It's really, really technical. This is an area where if you are engaged in merger, if you are engaged in an acquisition that clears that $126.4 million size of person threshold, please get antitrust counsel involved. We'll kind of skip over a lot of the rest of the HSR stuff, but that's the one thing to take away from this. If you meet that size of transaction threshold, $126.4 million, get antitrust counsel involved. If you don't make an HSR filing, and you should have made an HSR filing, the fines can be significant. And we're talking up to about $50,000 a day for noncompliance. And so there are very real problems with not involving antitrust counsel in a transaction of that size. Fortunately, if you're entering into a transaction of that size, you probably have antitrust counsel engaged or somebody that knows that they need to engage antitrust counsel to do that analysis. Very quickly, even if the size of transaction, size of person tests are met, there are exemptions. Some transactions, some states have what are called certificate of public advantage programs that allow antitrust clearance to go through the Attorney General. And in that case, it's kind of opposite. Most of the time we think that federal law trumps state law, but in this instance, states can trump federal antitrust enforcement by approving transactions through a certificate of public advantage. FTC and DOJ hate these. FTC files suits against them all the time, more out of principle than anything else. But it's a way to get around an HSR filing in some instances. There are other federally recognized exemptions. There are a bunch of them. We just put a few kind of in notes here. You can see we're not going to go through these, but there are a lot, and you can get around them. Having said that, you cannot structure your transaction to intentionally evade HSR review. You can't do that. You can't buy 5 different offices of a physician group in 5 separate transactions for $50 million each just to get below that HSR threshold. The agencies are going to view that as not 5 $50 million transactions, but one $250 million transaction, for example, just as a hypothetical. And you can't restructure your agreement just to get around that HSR filing. So just be aware if you have a transaction that exceeds that threshold, get antitrust counsel to look at it. Along with the filing, you have to produce a lot of documents. You need to identify a lot of people that are involved in the process. If there is competition between the buyer and the seller, if they are competitors, you are going to have to produce a lot of information about the market that you're competing in and the products and services that you're providing that compete with each other. So just be aware of that filing. and you'll have to provide information about your directors so that the agencies can track interlocking directorates. You're going to have to produce strategic plans so they can see if this is going to impact competition. They're going to look at your prior deals to see if this is part of a string of transactions. And so there's a lot of things like that going on with HSR. But let's move on and talk quickly about federal enforcement now.
So what are the FTC and DOJ doing now? The question we want to think about is how has this changed with the new administration? And it's early, but there are definitely shifts.
All right, first, you really do have a philosophical change with the current administration and prior administration. The prior administration largely seemed focused on putting a hold on as many mergers and acquisitions as possible. That's an overstatement. It's overbroad, but it as a general matter, it's not too far off the mark. The FTC, for instance, withdrew a lot of its guidance that it had previously given antitrust practitioners, and that had been available for years and was treated as appropriate guidance for companies to follow as they navigated antitrust clearance with the FTC and DOJ as part of HSR filings. And then the FTC just withdrew it and said you can't rely on it. They withdrew a lot of their healthcare statements, statements that they'd made about healthcare, establishing safe harbors for certain conduct. And so what that served to do is create uncertainty. And that was the goal. It was to reduce the number of acquisitions and mergers that the agencies had to review. The prior administration also took a very skeptical view of private equity and saw it as extremely problematic. And so private equity transactions were given heightened scrutiny.
So what are the states doing? Enforcement and legislation, state enforcement trends. The enforcers have benefited from the prior administration's aggressive antitrust enforcement philosophy that Corey was talking about. With this new administration, at least preliminarily, it looks like states are continuing to be aggressive. The problem is they just lack the resources without federal support. So, time will tell how long they can continue on under that approach.
Stay tuned. Another thing that's come up is a lot of states have enacted what are called mini HSR regimes that require parties either to submit essentially their HSR filing to state regulators or provide information similar to that prior to closing to allow state enforcers to evaluate a transaction. And you can see a lot of states have these types of statutes in place, and a number of others have proposed them. One thing that's interesting about this is the HSR size of transaction threshold weeds out a lot of transactions that happen in healthcare. A lot of these healthcare transactions, just given the size, but many of the mini HSR acts don't have the same threshold or any threshold for these transactions. And if you've got a transaction where you are changing control of a healthcare organization, it can be subject to state reporting. And so you need at least to consider that if you're in one of these jurisdictions that has a mini HSR act. The other thing about the state acts is they can impact your closing timing. When you make an HSR filing, there's a 30-day waiting period. Some of the states have longer waiting periods. I think the longest one I've seen is in California. There's a 180-day waiting period, and I think that involves pharmacies. But it's something where you can't close before that waiting period ends.
So will there be a uniform state regime? Last year, the Uniform Law Commission adopted a Uniform Antitrust Pre-Merger Notification Act. It's not healthcare specific. It's triggered when an HSR filing is made and requires a parallel filing of the HSR filing in the adopting state if a filing person either has its principal place of business in the state or has annual net sales in the state of at least 20% of the HSR size of transaction threshold. There's no waiting period under this, and the legislation was introduced so far in DC and 7 other states. And Washington was the first to adopt the Uniform Act. That's
All right, and that's what we have. So we finished at exactly 1. Thank you all for attending. Again, if you have any questions, feel free to reach out either to April or to me. We're happy to answer them. And I hope that this was useful information for you. We appreciate you attending, and join somebody else in the healthcare group again next month for the next webinar. Thanks again.
Thank you.